In early 2020, the world faced a problem we have not seen in over 100 years. The once-in-a-lifetime global pandemic had us all staying at home, while public health officials, medical professionals, and scientists raced to find answers. Although we learned to adapt our new lives, the quarantine had a devastating impact on global economies and forced business owners to adapt to survive. Government officials across the globe instituted policies limiting capacities, hours, and even operating procedures, all to keep people safe. But what happens when your business depends on a crowd? Industries like restaurants, gyms, and concert venues took the full force of the quarantine. Small restaurants with limited space saw their profit margins steadily shrink as their customer base was sheltering at home. By the time we found ways to get back out and enjoy dining out safely again, it was too late to save some of the mom-and-pop style eateries. If government regulations make it impossible for a business owner to make a profit, does it become the government's fault that the business is closed? Should we bear the collective responsibility for compensating the businesses that didn't make it through the quarantine?
We'll hear arguments first this morning in Penn Central Transportation Company against the City of New York.
The Constitution doesn't prevent the government from effecting necessary regulations, and every action of government has to have some kind of an adverse effect on somebody.
The basic question is the regulation's effect on private property equivalent to that of a classic taking where the government appropriates or physically invades the property?
The Just Compensation Clause is not designed to interfere with the ability of government to affect property interests, but rather to require just compensation in the event of an otherwise valid taking.
I think in many instances there's just as much of a taking on the property owner when that something is done by regulation as by eminent domain.
Thank you, counsel. The case is submitted.
Although we talk about COVID-19 as being a once-in-a-lifetime global pandemic, public health crises like the current pandemic are not novel challenges for governments. The U.S. has had to respond to a number of infectious diseases throughout our history. From more recent concerns about possible transmission of the Ebola virus or outbreaks of the avian flu, the 1918 influenza outbreak, or even the smallpox epidemic at our nation's founding.
Public health regulations are not a new concept in the modern age. Although we have modern tools like vaccines and statistical modeling, governments have been creating regulations to prevent the spread of illnesses for centuries. Pop culture is littered with references to government responses to pandemics. In fact, a government-enforced quarantine plays a central role in Romeo and Juliet. So even in the world of Shakespeare, the government was responsible for keeping the public safe from threats like a deadly disease. Historically, the role of a just government has been to fulfill the social contract. Unlike the monarchies of the past, where the people lived to serve the king, a government based on a social contract existed to serve the people. The founders believed in this concept of agreeing to cooperate in order to derive social benefits. The preamble makes this abundantly clear when it speaks about promoting the general welfare. But this general welfare isn't free. We can't derive something from nothing. So ordinarily, the cost of providing that public benefit is distributed across the whole society, which is essentially the broader concept of a tax. In instances where the burden falls not on the broader public, but rather on individuals, we have structures in place to compensate them for their loss. The idea is not that individuals will never have to sacrifice, simply that when a sacrifice is required, the burden of that sacrifice should be distributed fairly.
Long before the first Europeans set foot on American soil, the origins of American law were sown in the English meadow of Runnymede. In 1215, King John and the barons of England met to agree on the most basic rights of Englishmen, the signing of the Magna Carta, or Great Compact, established a written list of the rights that the Crown would be forced to respect. Among these was the basic tenet that the king could not seize the property of a baron without due process of law. The barons recognized that sometimes their property would need to be sacrificed for the greater good, but that if such a sacrifice were needed, they would expect due process and compensation for their loss.
The concept of takings is easiest to understand in the context of physical property. Imagine that the government needs to build a new highway that just happens to cut directly through your property. The fact that you own the property and that your house is squarely in the middle of it does not mean that the government can't build the highway. But the Due Process Clause and just compensation provisions of the Fifth Amendment require that the government follow certain procedures in dispossessing you of that property, and that they fairly compensate you for the loss. Typically, the government does this through a practice known as eminent domain. This has been a non-controversial view throughout legal history. Where things get more complicated, however, is when the government passes a regulation that impacts your property. They're not physically taking it, but the regulation is so onerous that it has basically the same effect. This argument is raised for the first time in a 1922 case, Pennsylvania Coal Company v. Mahan. In that case, the dispute arose after the passage of a Pennsylvania law that prohibited mining coal below any surface that supported buildings. The Pennsylvania Coal Company, which had an existing contract to mine coal below Mahan's land, argued that the law essentially stripped them of their property right. In a departure from the traditional view of takings as a physical dispossession, a nearly unanimous court agreed.
PA Coal v. Mahan introduced the idea that sometimes regulations go too far and thereby result in a taking. Figuring out the confines of what is too far would take a few more years. The court got its chance to establish the test in Penn Central Transportation Company v. New York City. In 1965, the City of New York passed a landmark preservation law, giving the city the power to designate certain buildings as historic landmarks. That designation brought with it a host of limitations, including bans on alteration and construction. The hope was to preserve these historic buildings for the enjoyment of the public. Grand Central Terminal, constructed in 1913, was one of the buildings designated by the Act. Prior to the landmark designation, Penn Central Transportation Company, which owned the terminal, was in negotiations to build a multi-story office building above the site. Since the landmark law stopped them from pursuing a very lucrative project, Penn Central brought suit to argue that the regulation amounted to a taking of their property.
You don't question the right of the City of New York to take this entire property, do you?
No, Your Honor. The issue raised here is not, as some of the briefs seem to suggest, whether the City of New York may validly preclude Penn Central from constructing a building. 25 years ago in Berman and Parker, this court, in a unanimous opinion, proclaimed for all that it's just as appropriate for government action to look to things that beautify and enhance the quality of life as it is to do away with things that are unsanitary. But the issue here, simply stated, is who's going to bear the loss of the burden that's occasioned by this substantial public benefit.
Although the court didn't rule in favor of Penn Central, their decision would become the central precedent that all future regulatory takings arguments would build upon. They took the idea from Pennsylvania Coal and added a few more specifics to guide the future litigants in knowing just what they meant by too far in their prior decision. The Penn Central Court outlined 3 factors for consideration. First, the economic impact of the regulation on the claimant. Second, the extent to which the regulation interferes with investment-backed expectations. And third, the character of the government action. The court made it seem, in their opinion, like these factors create a bright line rule for figuring out when a regulation has gone too far. All of the case law that follows shows that these factors are highly fact-specific and make it exceedingly difficult to predict the outcome of any case based on precedent. In fairness, the legal situation around regulatory takings has been a bit of a mess.
The mess the case law has created is exactly what opens the door to the cases pending before the courts as we begin to reopen. Hollis Fitzpatrick was the proud owner of a diner in the state of Buckeye that has been in their family for generations. Through good and bad, the diner was a staple in the community. That is, until the pandemic changed the restaurant industry. Like many state officials, Buckeye Governor Fran DeBier used their authority to issue regulations to keep the public safe. The governor initially closed all restaurants and bars to limit the spread of COVID-19. As we learned more about the virus, Governor DeBier issued new regulations allowing restaurants to reopen with safety procedures in place. They set limitations on capacity to reduce crowd size. Restaurants also had to follow social distancing protocols to minimize contact between guests and were prohibited from operating food service options like buffets and soda fountains. With these limitations in place, Fitzpatrick argues that their business couldn't survive.
The Fitzpatrick case is kind of complicated. Right from the start, in the way the case gets named, it's confusing. Normally, in a case, you have plaintiff against defendant, or in a criminal case, you have prosecution against defendant. Something like state v. accused. But in this case, you're not seeing Fitzpatrick v. Buckeye. The way this case comes to court is a bit different, or in legal speak, the posture of the case is not party A against party B. In actuality, the aggrieved party is trying to force the government to conduct the due process required to take the property that their regulations have impacted. They do this through a writ of mandamus, or a legal action to move the hand of the state. So the case is technically the hand of the state being forced by an individual against the state actor that harmed the individual. The person seeking the action becomes the relator. So in the present case, that's Fitzpatrick. And the party that affected the taking via regulation is the respondent. So here, that's the governor and the other members of the executive branch responsible for those regulations. The Fitzpatrick case is coming to trial with a limited set of issues to resolve, which makes the trial more focused than it would be otherwise. Prior to trial, both sides submitted briefs and motions to the trial judge for consideration. As a result of their pretrial motions, the judge has granted summary judgment in favor of the state on a few issues. First, the trial judge has already ruled that the regulations did not constitute a per se taking. That is, the regulation closing the restaurant entirely was not akin to a physical dispossession of the property. Second, the judge has already ruled that the regulations do not affect a total taking, because Fitzpatrick still retains some value in the property and their business. The net result of these preliminary rulings is that the trial will be left to resolve the question of whether the regulations were a partial taking. In order to succeed here, to get the government to acknowledge a taking, Fitzpatrick needs to establish that the regulations created by the governor and the health department meet those Penn Central factors, those three considerations that show when a regulation goes too far. The state, on the other hand, needs to show that those same Penn Central factors actually swing in their favor and that no taking occurred. Fitzpatrick needs to bring evidence into court to show that the restaurant suffered substantial economic losses as a result of the regulations, that the regulations interfered with reasonable investment-backed expectations, and that the nature of the regulation was such that it unfairly discriminated against some businesses more than others.
Based on the filings submitted during discovery, Fitzpatrick will attempt these arguments using three key witnesses with first-hand knowledge of their restaurant's operation, its finances, and the disparate impact of the regulations on small restaurants compared to others.
The most obvious first witness in a case like this is the business owner themselves. So Hollis Fitzpatrick can give first-hand information about the operation of the restaurant before and after the regulations. They can talk about the investments they've made in the restaurant and the impact the regulations had on the business. They will also have knowledge of the other avenues they explored for making a profit in the space, which has been an important consideration in past cases. Although any business owner would have some knowledge of their business financials, Unsurprisingly, the relator is relying on a more knowledgeable party to lay out the evidence in more depth. For the Fitzpatrick case, they are relying on Phoenix Anderson, the accountant. As the bookkeeper for the business, Anderson will have a lot more knowledge about the profit margins of the business, how many customers they needed to serve to turn a profit, the expenses, etc.
The Fitzpatrick case is first of its kind to test the COVID-19 restrictions, and many other businesses are watching carefully. A win for Fitzpatrick would pave the way for countless other businesses to seek compensation for their losses. When a case of this nature comes up, it is pretty common to also see input coming from industry representatives like the Buckeye Restaurant Association.
The restaurant industry has always faced a fair amount of regulatory oversight. Whether this be in the form of food safety laws or liquor licenses, restaurants are really no stranger to rules. The regulations that were put in place in response to the COVID-19 crisis, however, are of a very different nature. When Hollis Fitzpatrick reached out to us at the Buckeye Restaurant Association, it was an easy choice to agree to testify. Our director, Finley Ibarra, can testify in this case about the history of restaurant regulations and how the pandemic represents a shift in the regulatory landscape. Our membership at the BRA represents a large swath of the restaurant industry. We've got everything from tiny three-table cafes to global chains. This is going to give Director Ibarra a good handle on how the regulations have impacted all of our members differently. And of course, it will also show the disproportionate impact that these restrictions have had on our small business members. Director Ibarra can also talk about the different services that we offered to our members during the pandemic, like industrial designers to help maximize their floor space. Our organization is here to support our members through every stage of their business, especially when they need us most.
The state of Buckeye obviously has a significant economic interest in the outcome of this case. It's always been our position that a taking should result in just compensation, but the reality is that this simply is not a taking. Penn Central and later cases make clear that the state can pass regulations that have an adverse effect on some members of society. That by itself does not create a regulatory taking, and it certainly doesn't entitle them to compensation. The COVID crisis took a heavy toll on all of us, and defeating it and keeping Buckeye safe required community effort. Governor DeBier and Buckeye Director of Public Health, Hollis Fitzpatrick, worked relentlessly to keep the economy of our state strong while simultaneously keeping Buckeye safe.
Director Mazakis is top of the list of witnesses for the state, being the most qualified individual to talk about the decision-making processes that went into the regulations, how they compare with other regulations restaurants must follow, and the ways in which the regulations applied equally to all members of the restaurant industry. Health regulations have a long history in the United States, and places of public gathering have always been a prime candidate for controlling the spread of infectious disease.
The overwhelming fact also remains that Hollis still retains significant assets in the business that are not destroyed by the temporary regulations. It wasn't hard for us to find examples of other restaurants thriving even in this difficult time, and there were plenty of things that Fitzpatrick's could have done to turn a profit.
The state of Buckeye will need to put on comparison evidence that shows the value remaining in Fitzpatrick's and how other restaurants managed to turn a profit despite the pandemic. One witness who will be particularly well suited to put forward this evidence is Riley Zhang, a real estate agent with knowledge of the business scene in Harmony. They can help the state make the argument that Hollis had a lot of other options for making money, and that the state cannot be held to answer for the failure to do so. As someone with local knowledge, they can also talk about how the regulations affected businesses of similar size to Fitzpatrick's, rebutting the argument that the regulations unfairly discriminate against small businesses. Zhang also has past dealings with the financials of Fitzpatrick's as part of a prior proposed development deal, so they'll have a lot of insight as to how healthy the business actually was before the pandemic regulations went into effect.
The state also has what they hope will be an ace up their sleeve, an employee who is around both before and during the pandemic.
Aspen Bennett's testimony will show that the reality Fitzpatrick is putting forward simply isn't true. The regulations were not the cause of their business's failure. but a backdrop of a business already in decline. As an employee that was present for day-to-day operations, Bennett has particularized knowledge of the way that Fitzpatrick conducted their business both before and during the early stages of the pandemic. They can speak to the unwillingness of Fitzpatrick to make changes that would have allowed them to be profitable even with the restrictions in place. Changes that their current employer willingly made with great success. The takings clause is not a curative for unsuccessful businesses to recoup their losses. And nothing in the Constitution obligates the state of Buckeye to pay Fitzpatrick for their inability to make a profit from a sinking ship.
The COVID-19 crisis has certainly posed some unusual challenges for state and local governments. Making the hard choices to shut down our local businesses may have kept the public safe, but should individual business owners like Fitzpatrick bear the cost of providing for the public good? The last time a major health crisis arose, the concept of regulatory takings didn't exist. The influenza outbreak of 1918 was accompanied by many of the same social distancing and stay-at-home orders that we are seeing today. But regulatory takings were not acknowledged until 1922. Perhaps, if they had been, we would already have our answer.